Good morning, all. This directions hearing is in the matter of CFI 020-2023 before His Excellency Justice Thomas Bathurst, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Nasser H. Bajamal Limited. Lead counsel is Mr. Amr Bajamal. The defendant is represented by Nisma Janahi Advocates and Legal Consultants, with Mr. Tim Al-Garawi seeking to appear on its behalf. Thank you, Your Honor.
Thank you. Mr. Al-Garawi, there is a preliminary matter. As I understand that you're only registered as a Part 1 practitioner.
Correct, Your Honor.
You need to be registered as a Part 2 practitioner to enable yourself to be able to appear.
We discovered this last week when Ms. Alia informed us of this.
Are you prepared to give an undertaking that you will seek to be registered as a Part 2 practitioner within 48 hours?
We're undergoing preparations to make that application, Your Honor. Just as a quick explanation as to why this has transpired, when we sought registration in 2022, we were informed, perhaps this was a misunderstanding, not pointing fingers, we were informed that the Part 1 registration would be sufficient to conduct proceedings, which includes attending before the court.
I don't want a detailed explanation. Will you give an undertaking to seek to be registered within the next 48 hours?
I can undertake that. We will undertake to seek the registration, and we will keep the court updated on that status.
Thank you for that. I note that, and on that basis, I'll give you leave to appear today. Now, trying to get clear in my mind where we are exactly in these proceedings before I let the parties say anything. Firstly, what is the position now as far as lay witnesses are concerned? Mr. Bajamal?
Yes. Yes, Your Honor. Good morning. The position at the moment is that with regards to witnesses, we have served a new, well, in terms of content, it's not very new. However, it is in terms of the person who's given the witness statement. It's if Your Honor recalls.
I recall the difficulty. Yes.
Correct. Yes. So we've cured that at the moment, and we've one of our clients' employees has provided the witness statement, so that has been resolved. In terms of where we've reached with the other side on the other procedural steps.
No, I just want to deal with this matter first. So what about you, Mr. Al-Garawi? What's your position as far as lay witness statements are concerned?
I believe, yeah, as we discussed the previous hearing, I think the procedural defect has been cured. They've shared a draft of the updated witness statement, and indeed, we offered no objections to the other side because there was no substantive changes. It was simply informed.
What about your witness statements?
They've been filed and served, and our witnesses we will endeavor to make sure they're available for cross-examination at trial.
They better be, otherwise we won't be relying on their statements.
Absolutely.
Thank you. So there's no difficulty as far as that's concerned. Now, what about experts? What's the position as far as experts are concerned?
From our side, Your Honor, so the defendant has sought an amendment to make an amendment.
Well, I want to know about your witness statements first. Have you got an expert witness statement?
We do have an expert report that was lodged at an earlier stage in the proceedings, and we haven't done any amendments to it.
And you intend to rely on that report?
Correct.
Mr. Al-Garawi, what's your position now?
We have also lodged 2 expert reports. I think the issue Mr. Amr wanted to allude to is the fact that the second expert report that we lodged.
The 2 experts reports, are they by the same expert?
Yes, Your Honor. The second expert report we submitted was effectively a supplemental expert report, yes, by the same expert.
Mr. Bajmal, firstly, leaving aside the question of costs for the moment, do you object to those experts' reports?
To the amendment or the original ones?
To both the original report and the amended report, because Mr. Al-Gharabi seemed to rely on both.
Right. Well, but with regards to the original report, it was not, none of the reports were served on us at the time, and therefore we took the position that.
I understand the position you took in the past. I'm dealing with it today.
Yes.
Do you have you got any objection to the reliance on either of those reports?
We don't have an objection on the reliance itself. We are seeking directions to give us an opportunity to comment on the basically for our expert to provide a rebuttal report as envisaged.
You seek to file an expert's report in reply.
Correct.
That's not unreasonable, Mr. Al-Gharabi.
Not at all, Your Honor. We believe that that's reasonable, and we have no objections to a reply expert report. It's only fair.
How long will it take you to have that done, Mr. Bajmal?
We've proposed some dates, Your Honor. So the date that we proposed was the 22nd of August. So yes.
The 22nd of August for your expert statement in reply.
Correct. What we call the supplemental expert response, or we may call it a rebuttal report. Yes.
It doesn't matter. I don't mind very much. Do you really need that long?
Sorry?
Do you really need that long?
It's just because we have proposed, because Mr. Gharabi has also amended his counterclaim. So the way we've proposed things to go forward is by the 15th of August, we provide our comments on there, or we provide an amended defense to the counterclaim, and then thereafter provide. So therefore, that's why we proposed it at the 22nd.
What's the amendment to the counterclaim, Mr.
Al-Gharabi? This is an entirely different issue we wanted to address today. We, as you recall, Your Honor, we tried to ask for permission to reduce the counterclaim, and in fact, I recall you chuckled and said that shouldn't be an issue. And in fact, the claimants have turned it into an issue when we sought their consent to reduce the counterclaim.
But is the only amendment, reading through the correspondence and the draft orders, I rather thought you'd abandon the attempt to reduce the counterclaim. That's wrong.
That's wrong. That we're still seeking to reduce the counterclaim. It is still a matter.
Is the only amendment a reduction in the amount claimed?
Correct. And two claims are being also withdrawn. I believe one of them was for damages for loss of business opportunity. We're also removing that. The counterclaim has been reduced to a single claim for, I believe, 4,000, 5,000 dirhams. And the claimant has objected to this. And then, well, let me be completely accurate. They did not object to it. However, they held their consent hostage by attaching a condition to it, which is neither here or there, and a very surprising situation for someone trying to reduce their counterclaim. And that is still something we are seeking to have ordered. They eventually granted their consent, but this was only after we had incurred costs and made an application in compliance with your orders, Your Honor.
Mr. Bajmal, do you agree? Please. Do you agree that the only amendment to the counterclaim was to reduce the amount claimed and abandon some claims?
Yes, on the face of it, this is the content of the amendment. However, there is now a reliance on amount, or Mr. Gharabi seeks to be awarded amounts that relate to an AMC. It's a maintenance contract. Now, the issue that we had at the time, when this is the incident that Mr. Gharabi refers to, is that we were approached to get consent 45 minutes before the deadline for filing. And at the time, we weren't able to get instructions from the client. So we took the position that we took because that was the way we thought that, you know, it's best to protect the position of the claimant.
I'm not being critical. I'm just asking.
Yes. So what we propose to do is amend the defense for accuracy, because at the moment it addresses many issues which may have become irrelevant, and possibly we might seek further instructions on the question of the maintenance contract and the claim relating to that. But yes, that's our position.
Very well. I'll grant leave to the extent necessary to the defendant to file an amended counterclaim containing the amendments referred to by Mr. Algramani at this directions hearing today.
Your Honor, sorry to interrupt. We've already done that because you've ordered
right.
this before, and we've already done this, and this is the point we're trying to raise here, is that
right.
after. Yeah.
Thank you. That's my mistake. In those circumstances, what I will do is I will grant Mr. Bajamal leave to amend his reply to the defence of the counterclaim. Such amendment to be made by, what date did you say, Mr. Bajamal?
15th of August.
By the 15th of August. I'm not going to spend time here debating the questions of cost, which seem to me to be just an unnecessary dispute between practitioners. I'll reserve all questions of cost of the amendment. It may well be, if you can show that you've incurred substantial additional expense, Mr. Bajamal, I'll give you cost, but I just can't see it at the moment. So I think the best thing to do is to reserve all questions of cost of the amendment and of the additional experts report filed by Mr. Algramani until the hearing. So you're protected on those positions.
Thank you, Your Honor.
Your Honor, may I ask about our cost as well for the claimant's unnecessary hindrance with regards to this counterclaim reduction?
I've reserved all questions of cost of each. All costs include Mr. Bajamal's costs.
Understood.
That means experts will, if it should be completed by the 22nd of August, the pleadings hopefully will have been finalised by then, and the lay witnesses are complete. Now, we were penciling in a date in September for the hearing. I don't know if that's a bit early in all the circumstances.
Yes.
What's your view?
Yeah, I believe it would be early, Your Honor. So, but we've looked at our calendar, and we are available on the 1st of October. So we say that we will need 2 days with 1 day in reserve. So we propose to move the hearing to the 1st, 2nd, and the 3rd of October in reserve.
Bear with me a second.
Just looking at our firm's calendar, if I may suggest the 8th, 9th, and 10th instead of October, as we have a few arbitration and litigation deadlines the preceding week.
I'm unavailable on the 6th and I'm unavailable on the 9th. So I'm unavailable on the week of the 6th of October. I've got commitments that week. So it could either be, as far as I'm concerned, the week of the 1st of October. I think it's the week of the week of the 29th of September, or the week of the, we do it on the 14th, 15th and 16th of October. sorry, the 13th, 14th and 15th.
Okay, Your Honor, from our side, we're happy to do the 29th, possibly 29th to the 1st. Unfortunately, we already have a commitment. So the week beginning the 13th of October, we won't be able to do. And then we have another trial with the DIFC courts starting on the 20th.
Mr. Archimani, can you do the 29th of September?
We have an arbitration deadline then, Your Honor, so that's going to be difficult for us.
What do you mean an arbitration? What do you mean an arbitration deadline? Is it arbitration hearing or?
We have a filing due on the 2nd.
Well, you've got the days before the 29th of September, the days after it's finished, just to do that. No, I think I'll set it down for the 29th, the 30th, and the 1st.
Understood.
Other than that, you're going to have to go. For my part, well into November, which is not desirable. So I'll set it down for the 29th of September, the 30th of September, and the 1st of October as a reserve day, starting at 9 a.m. Dubai time to accommodate the time differences. And we should have a free trial review. What dates have you got available in late August, say the last week's August? Say the 26th of August, for example. 26th or 27th of August.
If we are waiting for confirmation from the registry for some dates on another matter. So perhaps we can coordinate this date with the registry during this week.
Well, providing it's convenient to Mr. Al-Jamani, I've already inconvenienced him once. I don't want to do it twice.
Sure, we will make sure that we get his consent on the day.
Very well. Well, these are the directions I'll make. I direct that the claimant file its defence to counterclaim on or before the 15th of August. I direct that the claimant file any supplemental expert report or report in reply by the 22nd of August. I reserve all question of cost arising out of the amendment of the counterclaim, all question of both parties' costs arising out of the amendment of the counterclaim and the additional experts report until the trial. I direct the parties to consult with the registry with a view for fixing a date for a pre-trial review after the 22nd of August. I set the matter down for hearing on the 29th and 30th of September with a reserve day of the 1st of October. The hearing to commence at 9 a.m. Dubai time, which, for what it's worth, is 3 p.m. Sydney time. Is there anything else?
That's it from our side, Your Honor.
Mr. Al-Jamani?
Your Honor, I've got a bit of a strange thing to raise, if I may take 5 minutes of the court's time.
Yes, well,
we've discovered recently, this has been something that's flagged by our client, that the hearing recordings are being posted onto YouTube. Now, we understand this hearing is in private and that hearings, of course, should be public. But of course, we take the position that the modern day equivalent of a public hearing would be to live stream a hearing or something equivalent, or perhaps posting to YouTube for 24, 48 hours, something reasonable. As it currently stands, they are on the internet forever. And a further point that we noticed while I was watching the recordings of the hearing myself, we came across 12 different ads. So we realized that monetization was also enabled So we felt it was a little bit inappropriate that the DIFC courts would be earning ad income from case details, the hearings, the likenesses of counsel. I'm not sure if Mr. Amr also agrees on this point. So these are the 2 points we are raising. And I guess the order that we would request is to have the videos removed. And obviously, if there are no facilities for live streaming the hearings in accordance with having a public hearing, then we would suggest posting them for 24 hours, 48, whatever, a week, and then having them removed after that. Certainly, there was never an intention that these recordings would be available forever. And of course, the second order we would ask is, at the very least, and in the alternative, to have the monetization on those videos turned off.
I'm not aware of any of this. Can I guess that at the outset you consult with the registry? I'm not. I will also raise it.
I apologize, Your Honor. We did raise it with the registry, and they said you need to raise this with the judge, and the judge can make an order. We don't necessarily need your decision right now, Your Honor. We just wanted to raise it.
Look,
Interrupt, Your Honor.
yeah, thanks.
I just want to raise that correspondence with the registry in relation to the matter being posted on YouTube. This is just standard practice for public cases. And Mr. El-Ghauri was seeking to remove it, and in order to remove it, the matter must be private, and in order to make a matter private, an application is to be filed. And that was the guidance that was provided by the registry, not the guidance to raise it with you now. Thank you.
In those circumstances, I don't think I should make any order, Mr. Elderman. Having said that, I'll discuss the matter with the registry, but I'm not prepared to make an order which in effect would make this a private hearing.
No, Your Honor, and we're not seeking that. After we received the registry's advice, we do not want to seek an application to make this private. Indeed, we agree that it should be public for transparency reasons. But when I go and attend a court hearing on the Strand or in the DIFC courts in person, there is no recording available forever. So the fact that we are having these hearings online and they are being recorded is fantastic. And should they be live streamed, that's excellent. They should be public. Should they be posted on YouTube? Again, we have no objections. But the fact that they remain on there forever is a little bit surprising. And of course, there's the issue of the monetization, which is a bit strange and inappropriate. So that's how it differs our position now from when we last spoke to the registry. We do not seek an order to make it private.
Well, in those circumstances, I'm not prepared to make any order, but I will discuss it with the registry following the conclusion of these proceedings. That's about all I can do at the present time.
That's all we can ask, Your Honor. Thank you very much.
Thank you. Very well. We'll adjourn to a date to be agreed upon after the 22nd of August, and with a hearing commencing on the 29th of September.
Thank you very much, Your Honor.
Thank you very much. Thank you.
Thank you, Your Honor.